Thank you, Mr. Chairman. I'd like to thank each of you for coming, and I also want to thank Chairman Durbin for convening this hearing, which I think addresses one of the most important issues of our generation. This was a central focal point of my campaign for the U.S. Senate. It's also something that I've focused on extensively since coming to the U.S. Senate. I feel so strongly about the fact that we need a balanced budget amendment that I've even written a book about it. So needless to say, I am an advocate of this. And I'd like to respond, before I get into questions, to some of the points that have been made today. First of all, I think one of the reasons we need to remember why we need this is because, as fun as it is to say that Congress just needs to do its job, one of Congress's jobs, as it has perceived it, and one of its jobs, as is made clear in Clause 2 of Article 1, Section 8, is to borrow money on credit of the United States. The problem is that that power has been abused to the point where we're now $15 trillion in debt, to the point that by the end of this decade we'll be paying close to, if not in excess of, $1 trillion a year just in interest on our national debt. Now, this is no longer a simple debate between liberals and conservatives, between Republicans and Democrats. Because whether you're most concerned on the one hand about shoring up our ability to fund national defense, or on the other hand, most concerned about making sure that we have enough money to fund entitlement programs, you have to acknowledge that the roughly $800 billion delta between what we're paying in interest right now and what we could be paying in interest just a few years from now has the potential to bring about devastating consequences for every federal program, from defense to entitlements. This isn't a situation in which we can just do nothing, because doing nothing will bring about a situation in which we're forced to make abrupt, draconian, and very painful cuts to every federal program, and including and especially those upon which the most vulnerable members of our civilization have come to rely. That's why I think it's irresponsible for us to pretend that there isn't a problem that we have to address. I want to address the problem that suggests that somehow this would be dead-letter law unless we turn over the entire budgeting process to the courts. I respectfully but most forcefully disagree with this point. First of all, we have to remember that particularly when Congress is entrusted with certain constitutional responsibilities, it does take them seriously. There are a number of instances in which Congress is required to pass certain things by a supermajority threshold. That's required in the case of expelling a member under Article 1, Section 5, takes 2/3 of that House. That's the case under Article 1, Section 7, Clause 2, where it takes 2/3 to override a presidential veto. And yet we don't find ourselves mired in litigation every time those thresholds are implicated, or in the case of Senate ratification of a treaty. This is simply that. This is a supermajority requirement that says Congress needs to spend no more than it takes in, and Congress needs to spend no more than a fixed percentage of GDP, keeping in mind the fact that there ought to be a limit to how much out of every dollar the federal government ought to be able to take and consume before it's even spent, and spend money that future generations have yet to make on behalf of people who one day have to pay it back, people who are in some cases not old enough to vote, in other cases not yet born, in other cases people who will one day be born to parents who have yet to meet. This results in a really nasty, pernicious form of taxation without representation. We fought a war over that. We won that war. Now, if you're suggesting that if this did result in litigation, and I understand your standing concerns, I addressed that in Senate Joint Resolution 5. It's not directly addressed in Senate Joint Resolution 10. I wish it were. I will continue to keep that in mind. But if it were to result in litigation, there are benchmarks against which Congress could ensure that the litigation would not be mired down for years, that it wouldn't have to result in extensive discovery. The balanced budget amendment that all 47 Republicans, including myself, have co-sponsored, provides that Congress may, by appropriate legislation, enforce the terms of this amendment. This means that Congress could identify as a particular entity, a particular office, perhaps the Congressional Budget Office, as the entity in charge of deciding whether or not a particular budget is or is not balanced. This could result in a binary compliance standard, one in which the CBO either does or does not say it's in compliance. And then you could have a court, assuming that you could get around the Article 3 justiciability issues, that I believe you could, because with respect, I think Raines versus Byrd, although it makes some important points in this, it's not necessarily the inexorable command that you could never have a member of Congress withstanding, or regardless of what we came up with. So, Professor Morrison, in the few seconds I have left, I'd like you to just answer the question. Have we ever had extensive, protracted litigation on issues of public importance, national importance, that have focused on whether or not Congress has complied with its mandate to pass certain things by a supermajority?
The question is whether a court has ever had to decide whether Congress has complied with the requirement. The answer is there is a case involving the question about whether or not a revenue bill originated in the House of Representatives or not. And the court decided that question. That's a kind of technical compliance question. But no questions involved.
And how did the court decide that case?
It decided that the bill had originated in the House of Representatives.
Okay, so in that one case, the one case that you can point to where that resulted in litigation, the court decided it.
But that's
and
a very different
kind. It didn't mire the country in months and months or years and years or decades of litigation, did it?
Very different kind. It's a pure legal question. No facts at you, no discovery. Now, can I say a word about the Congressional Budget Office, for which I have a great respect? Under the Graham-Rudman case, it is perfectly clear that unless you make another part of an amendment to the Constitution, the Congressional Budget Office cannot carry out the function of deciding whether the Congress has complied with the Constitution or not, or whether a particular budget is in line with the Constitution. That would either have to be given to the President or to the courts. The Congressional Budget Office is part of Congress, and separation of powers is very clear that the CBO cannot do that. As far as Raines against Byrd, I was the losing lawyer in that case, so it pains me.
It's masterfully litigated, nonetheless.
Yes, yes, but we won on the merits eventually. And if I may say a word, I regret the passing of your father, with whom I worked on many cases on both sides.
As do I. We miss him. Thank you very much.